is not available. So we are going to be a four-man board tonight. At this point, I would entertain a motion to open the public hearing.
So moved, Mr. Chairman.
I got a motion. I need a second.
Second.
I got a second on Mr. No. Mr. Galley raised his hand. I got a second on Mr. Galley. So we're going to do roll call vote. Myself is yes. Mr. Baker Jr.
Yes.
Mr. Galley. Microphone's off.
Yes.
And Mr. Baker Sr.
Yes.
Here we go. All right, so let's look at the agenda for 7:30 p.m. 189 Greenwood Street, Rockland, Massachusetts. Notice hereby given in accordance with Massachusetts General Laws, Chapter 40A, Section 11 and 15. A virtual remote public hearing will be held by the Rockland Zoning Board of Appeals on Tuesday, November 18th, 2025 at 7:30 p.m. on the appeal of the decision of the building commissioner / zoning enforcement officer pursuant to Section 415-92 submitted by CM Futures LLC of 189 Greenwood Street, Rockland, Mass, seeking to overturn the zoning enforcement officer's findings that provisions of Massachusetts General Law 40A Section 6 result in a merger, that the provisions of 405-26B do not protect against merger. The property is located in the R2 resident zoning district, 415-9 of the zoning bylaw, and is identified as lot 36, map 23 on the Rockland Assessor's maps. The owner of the property is CM Futures LLC, 39 Donna Drive, Hanover, Mass, 02339. And with that, I'm looking for the applicant or the applicant's representative. Who are we speaking with? Thomas Patch, I can't hear you. Oh, technical difficulties are all over the place.
Hold on a second. Okay, can you hear me now?
There we go. I got you.
Okay. I'm attorney Tom Patch. I'm here tonight representing the petitioner CM Futures LLC and on its application, the appeal application. With me tonight are two duly authorized managers of the LLC, Robert Fell and Jamie Fell.
Fells, how you doing? I thought Jamie was going to say, hey, he turned his mic back off.
I'm here.
There he goes.
Same.
Okay, just wanted to make sure everybody knows who's who here. So Attorney Patch, if you want to talk, the floor is yours.
Sure. Thank you very much, and Chair Rosa, and thank you, board members. So what I did, and I apologize for the lateness of it, I prepared a memorandum trying to summarize, I guess, what we see as the issue, what we see as the resolution of the issue.
Can I ask one question before you go into the memorandum?
Yeah.
Can you summarize for the board what the zoning enforcement officer is saying that you don't agree with?
Okay, well, and therein lies the rub, okay? Because as I pointed out in the memorandum and in the application, this was sort of a cart before the horse thing. This is very unusual. We did not make a formal request for a zoning interpretation. We did not file a building permit. This was not an enforcement action. So as a result, it appears the zoning enforcement officer did this on his own initiative. And whether it was preemptive or, he was just trying to get ahead of it, we don't know. But the problem as a result of that is, as I tried to explain in the memorandum, we really never got a chance to present our full position to the zoning enforcement officer about, why we think these lots hadn't merged. And so there's been this back and forth going on where, I initially requested that the zoning enforcement officer, tried to discuss with town council that the zoning enforcement officer would perhaps rescind his decision so then we could make a formal request, document it, so everybody would be on board. Okay, he'd be fully informed.
Okay.
That got nowhere, unfortunately. We were just basically instructed or recommended to appeal to preserve our rights. So then what happens? So basically, it appeared that the underlying basis for this, as a result of discussion with town council, was in fact that there's been this merger of the two lots. So we proceeded, and I restated the email response from town council in the memorandum for the benefit of the board. So we proceeded on that, and then subsequent to us filing the application, it seems like the issue is somewhat morphed. But as I tried to point out in the memorandum, at the end of the day, the issue here is whether or not the lots have merged, because the issue of whether or not it's a buildable lot, and I'm not familiar. I know, Mr. Roser, you're a surveyor, correct? Right?
Mhm.
Are you a surveyor? Yeah. So you're somewhat familiar, and I'm not familiar with the other board members, so I apologize. I don't know how familiar you are with this, but the difference. But the filing for a building permit, there's a number of reasons why you could be denied. And what we're trying to focus on here is whether or not these lots retain their separate identity for zoning purposes, even, and that's a concept that's hard for people to understand, is that you can have a lot recorded at the registry of deed on a plan. That's great for the registry of deeds. That's great for the title. But zoning can look at it differently. Okay, zoning, the question becomes, is it a lot for zoning purposes? So, so basically, essentially, you can still have a lot under zoning because of the, safe harbor from the merger doctrine, but it may not be buildable. And the reason is that, in order to have a lot that's still a lot, it has to have the required, it has to have safe harbor frontage and area, so to speak. In other words, it exists as a lot. It's not protected necessarily from the increases in the yard setbacks, which apply to the building itself. So if you follow me, you can have a lot. The question is under zoning, but may not be buildable because of the application of the increased setbacks, which the safe harbor doesn't protect you against, basically make the lot unbuildable because you can't fit a house on there for that reason. So it's a fine distinction. So basically, what we've tried to do is point out, because what happened was initially we hadn't completed our due diligence when the building commission or the zoning enforcement officer acted. We were in the process of doing all this digging, and so I hadn't even reviewed all the chronological history of your zoning bylaw at that point in time. It was only subsequent to sort of that initial discussion I had with town council that I left it. I need to do more digging, which I did. I spent time at town hall. I spent time at the public library going through the town reports. I've tried to reach out to find the minutes of, planning board hearings because they have to statutorily hold hearings on zoning changes, as well as the finance committee, type, because they'd be warrant articles. Unfortunately got nowhere there. I guess Rockland had a pretty devastating fire a number of years ago in which a lot of historical documents were lost. So basically what I found was in the original zoning bylaw, there was this prior recorded lot provision, and it fits the situation of my client's property because the one lot, there's predecessor titles, the Unwins had bought it, the one lot, that's lot 35 on the assessors. They built a house and then they acquired the lot next door. And that was in the late 40s to the early 50s. It was before zoning came in. So if you read the prior recorded lot provision, it deals with lots that are in a recorded deed or plan prior to the notice of the first hearing by the planning board on the original zoning bylaw, which occurred in the beginning of February of 1958. I can give you the exact date if you want. It was, bear with me one second. blah, 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 blah. It was the zoning, the publication of the first notice was February 6th of 1958, and I got that out of the town reports. So basically, it's clear that the prior recorded lot provision applies to the situation. And what that does is basically prevents, it says, in effect, that if you have this vacant lot, which next to an improved lot, which was the case, it continues to have its existence. And, as long as you meet the requirements, and then it goes on to talk about reduction in side yards. So that provision was in force in effect in 1975 when we got what is the 26B provision that came in. And the 26B provision, we were looking at, that was the initial provision we looked at because of the language may continue. The whole point of the merger doctrine is something may not continue. Okay, it may not continue as a separate lot. You lose your identity as a lot. So if you look at 26B, 26B is talking about lots that don't have the area or dimension requirements, right? In other words, they're non-conforming. And it says they may continue so long as you do not further reduce that lot. So to try to give meaning to the may continue, that means it continues to exist as long as it was a lot in 1975 when 26B first came into effect. We know that lot 36 was a lot in 1975 when 26B came into effect because of the operation of the prior recorded lot provision. So essentially, that's what our argument is. Unfortunately, we never had a chance to discuss this with the zoning enforcement officer or town council because we were put into this position of having to respond to the determination. So what I tried to do, and like I said, I apologize. I am an attorney, and why use two words when 100 would do, right? So I did try to put, because we were informed by Ms. Quinn, the town planner, we only had 10 minutes to make our presentation on Friday, and I was like, wow, okay, I didn't see that coming. So basically, that's the reason why I tried to put together the memorandum for the benefit of the board members so they could, get into the meat and potatoes, essentially what we're saying. So basically, and again, what we're doing here is we're not seeking a deterrent. It's kind of an odd situation because our position is the lots haven't merged. But, and the reason is because ultimately what we want to do with lot 36 is try to acquire some land in the back from an abutter and create a retreat lot where you only need the 40 feet of frontage, but you need the double area. You have to double the area. And the problem is under the case law, when it deals with merger, if lots have merged for zoning purposes, so they lose their identity as a individual lot under zoning, if you tried to then sell one of those off or deed one of those off, it's a zoning violation. Yeah. So basically what we're trying to do is our pitch here is the lots did not merge. Okay. There would be any, because of area, because of the protection of it as a lot. You got to remember a lot is defined by essentially under the zoning is configured by area and typically width, okay? Yard setbacks really have nothing to do with the lot per se. It has to do if you want to build a structure on the lot and then have that structure then has to have certain yard setbacks which are relative to the lot itself, but it doesn't really go to the existence of the lot. So what we're trying to do is take the position and say the lots haven't merged. We're not seeking to build anything on lot 36. what we're trying to do is prevent it from being merged so that then we can proceed to try to negotiate with the abutter to acquire land from the abutter in the back to then create a retreat lot. So again, it's a fine distinction. A lot of people don't understand. A lot can merge, not merge, but yet not be buildable. So we really don't want to go there as to the building issue because that's not what we're really interested in. We're interested in having the lot not merge. So, so then we could essentially ultimately convey it without creating a zoning violation.
Gotcha.
Mr. Chairman?
Yes, Mr. Baker Jr.
May I ask Attorney Patch a couple of procedural questions?
Sure.
Absolutely, go for it.
I'm looking at the application, counsel, and
Speak up.
I'm sorry?
You were going muffled.
Oh, I'm sorry. I was looking at the application that's dated October 15th, and I'm assuming it was filed on the same date.
17th. It was filed on the 17th.
Okay. And I'm looking in particular at section 9 of the application, which says, explain in depth what you are proposing to do. And I appreciate the explanation that you've given us this evening.
Right.
But your section 9 on the application is, for all intents and purposes, blank. You reference some exhibits, but the exhibits don't set forth what you are contesting about the building commissioner's decision, what you propose to do, and why it's okay to do it. That, I'm assuming, is what the substance of the memorandum that you're discussing deals with. Is that correct?
Well, to be honest with you,
is that correct?
I'm confused because this is, because we got feedback from Miss Town Planner Quinn actually telling us she wanted us to eliminate a bunch of stuff in 9 because it's basically section 9. It basically explain in depth what you are proposing to do. So we basically.
Excuse me, Council, can you just answer my question? It
Well,
doesn't.
I'm trying to understand your question.
Does section 9,
yes,
since it only refers to exhibits and then nothing of substance, give us any hint at all what you want to do? And I'll answer the question for you. Since it's blank, it doesn't.
I don't understand why it's blank because
it's not blank.
Copy of
So it says
what it does say is it
in
says
terms of
see
substance,
exhibit
it's blank.
A, but there's no specific exhibit A attached to the application. It goes right from the application into a butters list, unless I'm looking at something wrong here. And then it's notes from the Board of Assessors. Then it's here's the appeal there's the notification from Tom Rubel. Then I got deeds. I've got the record plan. I've got the field card, 2 pages, and that's it. I don't see an actual exhibit that would go into a small, that actually go into what you're trying to say. So I see where Mr. Baker, I see where you're coming from.
When I said essentially blank, I was talking about blank in terms of substance. There is a reference to exhibits.
Yep.
But almost universally, exhibits are used to support a party's position rather than be the party's position. Okay.
Which I would agree.
All right.
I'm just saying.
Now, the memorandum that you referenced was delivered to or conveyed to the office just before 3 o'clock this afternoon, correct?
Mm-hmm.
I emailed it out, yes.
Okay. So that was less than 5 hours before this meeting.
Yes, and I explained why.
Well, and that's a 7-page single-space document, correct?
It is.
Okay.
It is what it is, yeah.
Yeah, well, and I guess my question, well, I don't guess. My question is, how would you expect the members of the board to develop any understanding of the matter based on the memo when you gave us not even close to reasonable time not just to read it, but to understand it. I got home from work at 6:30.
Yep.
I have not read your memo. I'm
Okay.
assuming that the memo is valuable in terms of your contention, your client's position, and certainly our understanding of that. And that having been said, I am in no position tonight to take an informed, favorable position on the client's application.
Okay, so the question I have, Chair Rosa, is
Mhm.
do you or do you not have this Exhibit A? Because that, like I said, that was
What
part
is Exhibit A?
it's basically, so if you look at the application itself, the application has certain enumerated things that they want you to address.
Yeah,
if
field
they're
number
relevant.
9 says see Exhibit A. What
And I,
document is,
and- right,
what
and I,
document is Exhibit A?
in each one of those, I said, see Exhibit A.
Yeah.
Yep.
So
What document is Exhibit A?
this document.
I can't read the
No,
screen.
no, I understand. I mean, I'm at a loss because this stuff was given, and town planner Quinn actually had communications with us stating that she wanted us to actually reduce what was in the Exhibit A, because essentially we were giving too much information. So, I'm at a loss here. I mean, this was filed. I don't know why it was not provided to you. It was filed as part of the application. So like I said, I'm at a loss why you wouldn't have that in front of you.
Can I ask
Yeah,
you a question, Attorney Pash?
sure.
Did you put together this PDF?
Which PDF?
I've got a PDF that has our instructions. It has typed out answers on our application.
No, well, I prepared some of it, Chair, but
Okay.
I was not the one who, I don't know who generated that PDF. I don't know if that PDF was generated by the town planner, by somebody when it came. I have no idea who generated that PDF
I
without.
got after the second page of the application, I've got the abutters list. Again, I did all this before. I'm just doing it again.
Yep.
I got the abutters list. I've got a letter from Board of Assessors.
Yeah.
I've got Tom Rubel's
Yep.
determination.
Yep.
I've got a series of deeds.
Yep.
Got a plan.
Yeah.
And then what was the last? And then 2 pages of field card. That's all that's in here. So it's a question of who put together, basically who put together the PDF, and was that Exhibit A a part of it?
Yeah. Well, but again, all that I can say is unfortunate the town planner's not here tonight because as I said, I mean, there was this, series of communications for her that she wanted us to actually reduce what was in the Exhibit A.
So what did
So
you supply
She
as a
was
reduced
explaining
version
it to
of
me because it
Exhibit
was
A?
very wordy. She was explaining it to me because it was very, very wordy. And the sheer fact was she was going to have to put all of that in the legal advertisement.
but that's not
Basically,
correct. But
that's
that's not correct. And
that's
I
what
had
I
that
heard.
discussion. I had that discussion with town council, communication town council Galvin, and he corrected her that that's not the case, and that's the reason why you have the legal ad that you have. Okay, and so I think there's a misunderstanding there on the part of town planner Quinn. I mean, and the fact that I would suggest, Chair Rosa, the fact that you're even acknowledging that you may have had a conversation with her saying it was too lengthy or whatever is evidence of the fact that it was in fact submitted. So I don't.
Oh, I'm not saying that it wasn't. I'm not
Right.
saying that it wasn't. I'm looking at what Mr. Baker's saying, in that it's not a part of the application. There is nothing that's a part of the application that fulfills that section 9 that we have in front of us.
They explain in depth what you're proposing to do.
Right. Not applicable. No, when it was see Exhibit A, which we don't have. That, I guess that's
But that's what I'm saying. You just acknowledged you had a conversation with the town planner about that very issue.
Yeah, she said that there was, she's definitely said that there was something in there.
Well, this Exhibit A, yeah.
Yeah,
I mean,
Mr. Chairman,
I can't explain administratively on your end why it didn't get to you.
That's,
You know,
we did,
that's
we,
fine.
I
we
can
did,
read, you know, for the
we did
benefit
get
of,
something called Exhibit A.
excuse me?
We did get something called Exhibit A. I printed a copy of it. I just found it. I'm trying to pull the email to see when we got it.
Okay,
I printed a copy of it.
I
nice.
have
really
a
quick.
copy of it
It's
too.
really quick. Exhibit A.
Right.
I have it. I printed a copy of it, but
13
I-
pages.
yeah, 13 pages exactly.
Yeah,
I got it from Allison on Friday.
Yeah.
Did
The whole
anybody
pack.
get the drawing?
And I want to be clear, Mr. Chairman, I wasn't suggesting that we didn't get Exhibit A.
oh
What
no,
I
it just didn't, it doesn't exist in the application.
What I'm suggesting is that there is no substantive information. Section 9 hasn't been completed.
Exactly.
There,
No, I'm
there
agreeing.
is,
That's what, and that's what I'm agreeing with you.
right, and the
Yeah.
exhibits that are attached would, in the normal course, and council agreed with me on this, serve to support what their contentions are, but do not satisfy the explanation requirement of those contentions.
Mr. Galley, you said you had it. Did you remember what date you picked that up?
I printed it off my email. That's why I was trying to find it really
Oh,
quick.
okay.
That's the problem. I'm like trying to find it when she emailed it to us.
I believe it was Thursday.
We'll
Did
need
anybody
something in the neighborhood of the
receive the,
13th. It sound right?
Proposed,
Let me see here.
We
That's
got
an
a draft.
application. It was on Friday. I see it Friday the 14th at 10:21. It was sent to the members.
It was Friday.
Reminder.
I picked mine up Monday.
Yep. And it says fell Exhibit A. You know, it's a Word doc. Well, at least that's what it looks like. I mean, I printed it already, but
Yeah.
stupid alarm.
no, don't open that.
The whole application is about 100 pages.
Give me that date
Turn
again.
this way.
When she
It was
sent that out?
November 14th, Mr.
Yes.
Chairman. And it's called Exhibit A to zoning appeal applications.
Mhm.
It's 4 meg in size.
It's a 2-page doc. No, 2, 3. Okay. I also have it.
You got all 13 pages?
I got all 1, 2, 3, 4. Oh, yeah. Pictures. Yeah. Unsigned, but I mean, I've got it. Mr. Baker Jr., do you not have this? I can email, I can email this to you.
I do have it, Mr. Chairman.
Oh, okay.
Yeah, but again, my concern isn't the absence or the presence of the exhibits. My concern, well, I have two concerns. The absence of any substantive information in section 9 of the application,
Yeah.
and the fact that the memorandum, which council is representing, would be beneficial to our understanding of this client's position, wasn't delivered until a month after the application was filed and less than 5 hours before we were to undertake consideration of the matter.
No, that's true.
Mhm.
I'm sorry.
Mr. Rose,
So-
Rose,
Did you guys not get
Yeah.
the Exhibit A until a couple of days ago? Is that what I'm?
Hold on. Rob, what's going on, man? How you doing?
Good, buddy. How are you?
Not
Sorry,
too bad. All
We
right,
fell
I've
through some
got,
computer issues over here for some reason.
it looks like we all have it. We
Okay.
all seem to have it. I found it in a different part of my computer. So I do have it. I do
Okay,
have it. I downloaded it a while ago. So
okay,
I do, and everybody does have it.
okay.
What Bob Baker Jr. is saying is that the exhibit itself does not satisfy the question.
Did you,
In
so did you get the proposed retreat lot plot plan photo?
that I haven't seen.
So that was included in the plan as well, in the email as well. But again, and I'll more than welcomely share it over to you, Rob, via email. I can get it to you right now, which gives you a visual representation of it. But I was specifically told that we were not allowed to discuss this in any way, shape, or form tonight. I was not allowed to bring it up or present evidence in matter to this, because the
Yeah.
only thing that was up for discussion tonight, specifically, was the zoning enforcement officer's determination that the lot is not buildable, as stated in his letter.
Yeah, that's all. Honestly, that's all we can really talk about because
Correct.
because that's the appeal.
Right.
Yeah, so but
And-
for reference sake, I can share the proposed plot plan with you and with everybody, if you can share it out to everyone, so you can get a visual representation of question 9. But ultimately, what we plan to do in the future, we were told not to bring up, not to show evidence of, etc.
We've got the
But
existing conditions one. We've got the existing conditions site plan. So we
if
know
you
that
have the existing conditions, then you also have the proposed plan as well, because they were together on the same email.
Again,
Yeah.
Chair Rosa, with all due
Yeah.
respect,
Yes, sir.
the second paragraph of section 9 says, and you can remember, when you look at your application gives very little room to provide responses. So if we just limit ourselves to the space on the application, you would have very even much less than what we tried to provide here. It says the second paragraph on 9 says the applicant is through the application seeking to appeal what appears to be on his own initiative determination of the zoning enforcement officer set forth in a letter to the applicant dated September 18, 2025, that applicant did not request nor submit a building or zoning permit, relief, or determination application in connection therewith. It being that the applicant's understanding of the basis of determination through representation of town council is that the zoning enforcement officer's assertion that the subject lot had merged with the adjoining lot property, town of Rockland, assessor map 35, as a result of the so-called common law merger doctrine, such that the subject lot is no longer a separate lot under the zoning bylaw, but is instead part of one lot under zoning that is comprised of the subject lot and the adjoining lot. With all due respect to Mr. Baker, I can't see.
Where were you reading that from?
I'm reading that from the Exhibit A. That's the second paragraph on 9. The first paragraph basically talks about what our ultimate development plan says. The first paragraph says the applicant is intending to ultimately seek to effect a development plan of acquiring additional land from a portion of the property address 956 Union Street, Town of Rockland, Assessor Map 2348, located to the rear of the land comprising the subject lot, and again gave the assessor's reference, to then combine same in order to create a retreat lot pursuant to section 415-28B. However, applicant has not yet filed an application for a building or zoning permit, nor a request application for a zoning determination or zoning relief in connection with this development plan, but is simply engaged in preliminary informal due diligence. And then I go on to the second paragraph, which basically says we're seeking through this application to appeal, blah, 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 blah. Again, I can't, that's asking us what we're proposing to do. And then
And I'm looking at the application that we've received, and I see no reference at all to what you just read.
Well, Chair Rosa, you say you have a copy of Exhibit A. Is that there? Is section 9 there?
It says Exhibit A. I can share the screen if everybody wants me to.
Yeah,
Sure,
if you could,
please
please,
do so.
Yeah.
Don't mean everybody sees that.
There
I
it
see
is,
it.
right there.
This was in a previous email. explain in depth. These are the two paragraphs Attorney Patch was reading. I also like to point out that he did reserve a right to verbally, talk about this. So in seeing this
I
and
don't
knowing that
see that in my package, Mr. Chairman.
Well, Mr. Baker, all I can say is it was not our doing.
Yeah,
That's all. And just so you, for your own comfort level, so tonight is a hearing where you can take evidence of all kinds. The board does not have to act tonight. You can take evidence, you can then deliberate, which would give you, for example, a chance. And I appreciate your concern about the lateness of the memo, but I was going to essentially state everything in the memo tonight, but for the fact on Friday, for the first time, we were informed by the town planner, we only have 10 minutes. And which came out of the blue because it's not in your rules of procedure. Some towns actually have a rule that says, your initial presentation is limited to X number of minutes unless the chair agrees otherwise. But there is, under these rules of procedure you guys have from 1980, there isn't no limitation like that. So, again, it kind of took me aback. So I said, well, I better, safe than sorry, I better prepare this memorandum. And that's the genesis of it. And my apologies, but that's the explanation.
Well,
Attorney Patch, guys, I have to go to Steve. He's been raising his hand for a while.
Thank you very much. I don't know the conversation. First of all, before I ask my question, I don't know the conversation that you had with Allison. I doubt she said you're limited to 10 minutes, but she probably suggested to keep it down to about 10 minutes.
Yeah.
I can't believe she said you have a 10-minute time limit. Like I've never had us put anyone on an egg timer type situation. We go, nope, you got to stop. So I just want to say, I don't know what your conversation was with her. I imagine that may have been a misunderstanding or a miscommunication or even a misspeaking on her part to be a devil's advocate. But here's my question that I've had for a while. What was the first communication that got to the zoning enforcement officer by the applicant that he reacted to come up with his statement and letter that you are now applying to the Zoning Board of Appeals? What did you ask of the town that they reacted?
Okay. In a formal sense, nothing. Informally, what happened was I reached, as part of my doing my due diligence, I reached out to the zoning enforcement officer and I wanted to discuss various provisions of the zoning bylaw. I was not looking to initiate a formal request. It goes on all the time. This is what's done. You talk to the zoning enforcement officer, you talk to the town planner, you talk to people trying to get this informal, doing your informal due diligence to see whether or not you even want to do a formal determination. And what happened was when I spoke with Mr. Rubel, he told me that I should contact Town Council Galvin because he was just going to defer to him. So on these matters. So what happened was I've dealt with Bob before. And so basically I reached out to Bob and basically telling him, this is what we're trying to figure out, et cetera, et cetera, et cetera. And he and I went back and forth on this. And the way I had left it with him was I'm going to have to do more digging on this. Okay. Which then, as a result of that, I then did the additional due diligence of going to the Rockland Public Library, going back through all your town reports, going back to 58, running it forward, trying to see whatever copies of the zoning bylaw that the town clerk had, and it doesn't have all of them. And I tried to reach out to the planning department to see, if they had minutes from meetings on zoning articles. That was unsuccessful. I reached out to the chair of the finance committee for the same purpose. I didn't get a response. And in the course of doing that, all of a sudden, then out comes this letter on the 18th, which is what I said. It kind of took us aback. And that's the reason why I communicated with Attorney Galvin and said, look, this seems to have been, for whatever reason, preemptive, because I was trying to figure out what the basis of it was, because we hadn't fully had an opportunity to present our position formally to the zoning enforcement officer, if there was a position to try to defend. And so, and then he sort of, came back with, well, it's his understanding that effectively that the lots had merged, okay, is what effectively is what he said. His understanding of the conversation that he had with the zoning enforcement officer.
Mhm.
So consequently, I basically said, look, you know, let us, is it possible that the zoning officer can rescind his application, his denial without prejudice so that we can then submit a formal request with all this documentation so that he has it in front of him and he can then evaluate this. We were not given that opportunity. Attorney Galvin just said, just file your appeal to reserve your rights. And that's what we've done, and it's unfortunate, but that's where we are. It's not for lack of us trying. And I didn't include all those emails and so forth because, I mean, I can certainly submit them if you want, but I mean, this is what happened. And so it wasn't, as I tried to point out multiple times, this wasn't our doing. We're not going to waste everybody's time if it's clear that there's no case to be made here. But in order to try to figure out whether there's a case, you do this informal due diligence in advance to try to figure out, okay, what are the parameters? What's going on here? Do I have to go all the way back and look at the zoning bylaw from its inception and then run it forward, which is essentially what I did. And look at the town reports because I was looking at the town reports to see if, for example, the report of the planning board or the finance committee or even the zoning board of appeals would shed light on what was going on. And because that would be something I would think that this board would want to hear, or, because it's what they call legislative history, essentially. The reason why the town did what it did. Unfortunately, I was unable to get that any kind of information. The town report for the committees is very scarce. And like I said, I did reach out trying to get the minutes or reports of the planning board or the finance committee. And I was, in the one instance, I was basically told those things don't exist. And another one, I never got a response by the chair of the finance committee. So it wasn't for lack of our effort, to do that. We'd much rather have put this whole package together for the benefit of the zoning enforcement officer so he could look at it rather than you guys essentially having to listen to this for the first time, but it was not, I kept asking Attorney Galvin, can you please have the zoning enforcement officer provide us with a formal written statement of his reasoning and his basis for this, and we never got it. The only thing I ever got from Attorney Galvin was his understanding based on his conversation with the zoning enforcement officer as to his rationale, which is the reason why I set it out in the memorandum to try to explain to you guys how this all happened. It's kind of, we're kind of here with two hands behind our back, but at the end of the day, the issue becomes, did the lots merge so that they lose their separate identity? And we're prepared to go forward on that because at the end of the day, if in fact the lots have merged and lost a separate identity, it's not a buildable lot. Do you follow? Do you know what I'm saying? But it can be a lot without being a building lot if you find it didn't merge, if there's the provisions of the zoning bylaw prevent it from being merged. Okay, so hopefully that is helpful in answering your question.
Okay, thank you.
Attorney Mr. Baker Jr., does that help?
I'm not trying to be difficult.
Of course you are. You're an attorney.
Okay,
You guys are all difficult. Believe me.
My dilemma is this.
Mhm.
And I was less concerned about the application than I was with the late submission of the memorandum.
Okay.
As I started to say before, I like to ask questions, but I like to ask informed questions. And I think with so little time I had no time to review that memorandum. And again, I appreciate counsel's explanation, but I would feel much more comfortable, and I realize I'm speaking only for myself. I would feel much more comfortable being able to read and digest that memorandum and ask questions based on that, as well as whatever other material has been submitted.
Now you guys have, I think the last day to, I mean, would you be, I know we'd be willing to agree to an extension of time, you know, for you guys, if that's what you want. You know, Chair Rosa, if you want, I'm kind of a Luddite when it comes to this Zoom stuff, but I do have, and I'm not trying to throw, you know, the town planner under the bus.
No, it's understood. It's understood.
But I mean, I'm looking right at the email, and it was November 14th at 10:30 a.m. and it said, "Please be prepared to begin promptly. You will have 10. So she spelled out the word 10 and then put the numerical 10 parentheses, 10 minutes to present your application." Okay. So you know, and again, I can share that with you. This is what it says. And that's why it kind of took me aback. I'm like, whoa, I better, you know, try to put together something. And unfortunately, and I hope Attorney Baker can appreciate this, you know, you have other work you're slammed with and you're trying to put something together, you know, and that's what I tried to do. And I can assure you, I wasn't trying to throw this on you guys at the last second. It was because of the fact that she said that we were only going to get 10 minutes.
That end is this is a little bit complex. There's some complexities here that need explanation. So
is it plausible for me just to give a brief rundown summary of just the basic facts that can all be kind of verified and gone through with respect? I mean, I know the application is lengthy and wordy and there's a lot in there, but I can give a very simplistic 2-minute narrative, I think, that might help out a little bit.
I think we've heard it already.
See, I was going to say, let's do this. We got a couple things we can do here. Number one, before we had the hearing and stuff like that, I tried to get Attorney Galvin in here because, again, there's some legal principles here that even that I don't fully understand. So it was one thing I thought was kind of necessary to have town council here. So if we did have any questions, we could talk to our guy. He suggested that we continue, so we can have a full discussion with town council and have him here at the next meeting.
I would be in favor of that, Mr. Chairman.
Okay, so we got that. Mr. Galley, Mr. Baker Senior, I know you guys have been sitting around. I know you guys have questions. It's a matter of, do you want to ask them now or do you want to ask them when we have our attorney present?
My questions require the attorney because they got it. Because, like you said, we're threading a needle on rules and precedent. So
that's a good way to put it. Mr. Baker Senior, how you feeling on that?
My questions are mostly for the town council.
Okay, so
The
I'm
other
going to
question,
make a
one question I
recommendation.
did have, Rob, if you
Of course.
don't mind.
Yep.
Should
You
we
always have one, so
should we have Tom Rubel here?
it would probably be good.
Well,
it
we're
would-
bringing up his name and his position in the
I
town,
know.
and he's not here to defend himself.
Yeah, no, I agree. Because one of the things that I did see, if I look at it, and I'm trying to understand, I'm trying to understand this. I got the letter, September 18th, 2025. In my opinion, property located 180 Green Street, Rockland, Mass, map 23, lot 36. In my opinion, is not buildable.
Right.
But yet he's not saying why.
Right. That was this Chair Rosa. That's what I then reached out to town council for. I'm saying, well, how do you expect us to prepare an appeal if we don't understand what his reasoning was this? And
when it all came down and I started looking at everything, then I understood why. You know, I understood why he was saying what he was saying. But again, it's one of those procedural things. I would think that it would be in there, the specifics.
Well, he would have said, I would have thought he would have essentially said what you see now in the public notice.
Yeah.
which is, see, and that's what I'm saying. The whole thing kind of evolved, and
No, I see. I'm seeing that now.
and that's why, listen, and I'm sure Attorney Baker can appreciate that I have to, obviously preserve my issues here. But it was a concerning issue in terms of due process, because it's sort of like, we're responding to this, but yet we're not being told, and we still don't have anything formally from the zoning enforcement officer himself. The problem comes, and I just want to put this on the record, Chair Rosa, is I understand you want to talk to town council, but now town council's right in the middle of this, because town council is the one relating to me, that he had conversation, Mr. Rubel's telling me to, and that's in my initial email to town council Galvin. And I said to him, the reason I'm reaching out to you is because this is what Mr. Rubel has told me to do, because he defers to you. And then basically, then it was the back and forth, but we've never gotten something from Mr. Rubel himself, a formal, such as this September 18th letter, something formally that he can be held to as his reasoning for why it is. And so unfortunately, we're basically put in this position of trying to deal with the third hand supposed, reasoning based on town council Gavin's understanding of what Mr. Rubel said. So, yeah, but at the end of the day, at the end of the day, what this comes down to is, and I believe Mr. Rubel had not obviously had the benefit of the argument that we're making in front of you tonight. But that's because it never had a chance to present that to him. But the issue becomes, he's interpreted the zoning bylaw and presumably the facts that these two lots are owned by my client. And they're side by side. I would think he has come to the conclusion that the general rule of merger, okay, for zoning purposes applies. And so because these lots are non-conforming or compliant with the presumptive minimum lot and area and dimension requirements. The frontage is 110 feet, and the area, I believe, is roughly 32,000 and change. Okay, neither of these two lots have that. So the theory of merger is, the general rule is essentially, absent something in the statute, the 48 statute, or absent something in your local bylaw that prevents these two lots from essentially being treated as one to reduce those nonconformities, okay, then these lots for zoning purposes, even though you go to the registry of deeds and you see on a plan they're two lots, for zoning purposes they're treated as one. So they're tied at the hip. They can't be separated from each other when you're trying to do stuff that implicates zoning. And so basically what we're saying here is, looking at your zoning bylaw, we are pointing to provisions in your zoning bylaw that we believe precludes the merger of these two lots as lots, and so that each lot retains, for zoning purposes, its separate identity. It doesn't necessarily mean the lot that has vacant has anything, can be buildable. It just means that they're not tied at the hip. So one can be conveyed from the other if without creating a zoning violation. Essentially, that's what it is. And what this common law doctrine of merger is, something that the courts came up with, in early 2001, there was this Preston versus the Town of Hull ZBA. That case gets pointed to quite a bit. But even in that case, the Mass Conveyancers Association filed an amicus brief, which is a friend of court brief, in support of the position that these lots hadn't merged, and pointed out, in the Zoning Act from 1975, essentially the legislative history showing that this merger thing was considered, but then they decided not to put a provision in the zoning bylaw, and yet the appeals court decided, well, we don't care about any of that. We think that this common law doctrine of merger has to be, grafted on the zoning statute 40A, so that because the purpose of one of the purposes of the zoning statute is to the gradual elimination of nonconformities. But it also provides special protection to 1 and 2 families, family residential uses. So there's this tension there. And so basically, the general rule is absent something in the zoning statute itself, or absent 40A, or absent your local bylaw having provisions that prevent this merger doctrine from occurring, because those provisions continue to give the lot separate identity as a zoning lot, then the general rule applies. So in order to address that issue, if the safe, what I call safe harbor, is not part of the 40A statute, you then have to look at your zoning bylaw, and you have to go all the way back. You have to start all the way back and run it forward. Believe me, it's an effort, okay? And, that's essentially what we've tried to do to present it to you guys, and pointing to these provisions and making an argument why these provisions should be viewed as essentially, the best word is creating a safe harbor for these 2 lots to continue to be separately, retain their separate identity as a lot for zoning purposes. They're not considered one big lot for zoning purposes.
You've given
Is
us
that
a
helpful?
lot to think about, absolutely a lot
understand.
to think about. There's a ton of information here. But in the end, I
Yeah,
think all the voting board members do agree that we need to hear from, we need to hear from town council to see where and how and if he disagrees with you. You
Yeah.
know what I mean? You've presented your case.
yeah.
I've got limited information from him. I need to know the whys and the hows at this point. It's not just the nope or
Yeah.
yep.
Well, presumably he's doing that on behalf of the zoning enforcement officer, because I'm sure you understand, Chair, and Attorney Baker in particular, I believe, would understand this. You're supposed to be a neutral, adjudicatory body,
Right.
so essentially, you got to be careful about, because essentially Attorney Galvin, if he agrees with, essentially, my understanding, he agrees with the zoning enforcement officer, but not based on what we've actually presented. This was earlier on.
Yeah.
So the problem is, if the town council is giving you guys advice, the problem is he's essentially defending his own position, and that would be a conflict. So for the record, I just want to make sure I get it out there. I'm not trying to cast aspersions on anybody. It's just, I got to do what I got to do.
But
Mr. Baker,
Chair-
Mr. Baker Jr.
Yeah, if, as you say, we are the adjudicator in this matter, and you're, at least by your description, suggesting the town council is on the opposite, or potentially on the opposite side of you, you wouldn't suggest for a minute that we shouldn't hear from that other side, should we?
Oh, no, but Attorney Baker, only if he is doing so as representing the zoning enforcement officers, as opposed to giving you guys advice. Okay, there's a distinction. He can articulate his position, saying, because he hit the zoning enforcement officer's position was a result of consultation with town council. So that position was the result of town council, because I've done town council work for the town of Kingston. It's a difficult situation when you're in these situations. But basically, if it's a result of his, which is my understanding, his consultation with the zoning enforcement officer, that position was developed, then he really is in a conflict position to then be giving you advice as a board. He can articulate his position and why, but to give you advice essentially would be a conflict of interest, because essentially what he'd be doing is giving advice on his own position.
I would respectfully disagree, but the world is.
Okay, all I can tell you is, having done town council, I've had that issue come up, and I had a judge lecture me on that.
Mr. Galley?
I just want to say, I'm not trying to get on Bob Galvin's Christmas card list, but I think I speak for the members of the board when I say that we have confidence and faith that he just tries to give us the best advice for the benefit of the town, not to protect one office or officer versus another. I mean, he will contradict. Obviously, the zoning enforcement officer denies people things that they have to come to the zoning board for. and the town council gives us advice on how to approve or disapprove, the reasons why, for, and against things. So I don't think any member of this board is concerned or afraid of him giving us advice that would somehow, contradict his job description or his oath of office or anything like that. I don't think there'll be any conflict of interest. I haven't witnessed it yet. I mean, I'm not the most expert law observer, but I haven't seen anything from him that makes me think that he's trying to protect his ego or his position. He tries to get.
All right, so let's
I'm
hold on,
not,
hold on,
Mr.
hold
Rosa,
on.
I'm
We
not
all
going
know
there.
this-
I'm not doing that. I'm just, I have to make it for the record because at least there would be an appearance of a conflict, whether, and again, as an attorney, Attorney Baker knows this, we're subject to the rules of professional responsibility. I have an obligation. If I see a potential conflict, I have to speak up, about it. So that's what I'm doing. I'm not throwing mud at Attorney Galvin. I've dealt with Bob on other issues. It's just, it is what it is. And I happen to know, having done town council my stuff, this issue does come up, and, the better course is to put it out there on the record, so then he can, it's, his decision, what he wants to do, you know, because he's the one with the conflict. As much as, with all due respect, as much as the board feels comfortable with him, at the end of the day, he has his, like myself, he has to comply with the rules of professional responsibility. And, that's a decision he has to make on himself. So casting no aspersions on him, but just, you got to understand, I'm just doing my job.
No, it's understood. All right, guys, this is going on for an hour now. So let's do this. No, hold on, Bob. Hold on. Let's do it. Let's do this. I got a text message from Allison that said if we are going to continue, if we'll continue the date of the next hearing is December 2nd, and we can go at 7:40 p.m.
That's
We'll
fine.
make sure that Bob Galvin's here. We'll make sure that Tom Rubel's here. Anybody else we want?
Your other member that was not here tonight can
He's actually here, but the problem is that he was not here when we opened the hearing.
But under the law, he can actually, there's an affidavit that he can set as long as it's only.
We know that, and I
Okay.
want to double check on that one because I've been told slightly different on that one, but if we can make that happen, then we can make that happen.
Okay.
So of the four members, I would entertain a motion.
So moved, Mr. Chairman.
I got a
Second,
motion
December
to,
2nd at 7:40.
that's exactly what I was looking for. I got a motion. Do I have a second?
second,
I got a second on Mr. Galley. Roll call. Myself is a yes. Mr. Baker Jr.,
Yes.
Mr. Galley,
yes.
Mr. Baker Senior.
Yes,
All right, so we're
that's
gonna,
what I raised my hand for, to make a motion to continue.
oh, okay. All right. Well, you should have made a motion. You were just doing this.
You cut
If
me
you did
off.
this,
You cut me
then that's a
off.
motion.
You cut me off.
I know. All right, so we got that. Attorney Patch, thank you. Mr. Feld, thank you. Who else? Who else was here from your team?
My wife, Jamie.
Oh, when I saw her name kicking around, but I don't. Oh, hey Jamie, how you doing?
Good, how are you?
Not too bad. So you heard everything that went on?
Yes,
We'll see you on what was it, December 2nd?
7:40.
We'll see you at 7:40 on December 2nd.
Sounds great.
Thank you all.
Thank you
Thank
all.
you.
All right, so where are we now? Let me get to agenda one more time. All right, so here we go, 7:45 p.m. 158 Central Street, continued from November 4th, 2025. Zoning Board of Appeals on Tuesday, November 18th, 2025, 7:30 p.m. Application submitted by Reynos and Beyond LLC for 158 Central Street, Rockland, Mass. For a variance pursuant to zoning bylaws section 415-22, building and lot requirements, side yard setback requirements. All building structures uses shall be set back no less than 15 feet from all external streets. Section 415-33, driveway across adjoining parcel, and section 415-89.1 variance. Applicants are seeking to divide off a portion of its property and create a retreat lot by an A&R approval process if the requested variance is approved. The property is located in the R2 residence zoning district, section 415-9 of the zoning bylaws, and is further identified as lot 77, map 55 on the Rockland assessor's maps. The owner of the property is Raynos and Beyond LLC, 3334 Street, Rockland, Massachusetts. Okay, who do we got here? Do I have to put on my glasses? Stacy and Bruno, what's going on, ladies? How you doing?
Hi, good. How are you?
Okay, so we're picking up where we left off last week. Who wasn't here at that point? Mr. Baker Senior, that was you, right?
Yes,
All right. Did you happen to look into the affidavit and the form you got to fill out?
what,
I'll take that. You weren't here, so as Attorney Patch was mentioning, and we know this, there's an affidavit that you can fill out and then watch the meeting, and then you can come in and be a voting member. Did you do that?
no,
Okay. So sit back and enjoy the ride. All right, ladies, let's start. Let's start again. Shall we kind of start again? Kind of rewind a little bit.
Sure. Whatever
Okay.
whatever you guys think. Let's all take a
Why
deep
don't
breath.
you? Yeah. Why don't you just tell us what you'd like to accomplish with this variance?
So the main reason for the variance is that if we put a retreat lot on the property, we only have 44.9 feet from what would be the new property line to the front corner of a 3-car garage that is kind of not straight in with the property. It's like cocked over to the side. And per your bylaws, we would need 55 feet, if I'm correctly reading it. So we need that variance for 10 feet, 3 inches from the front corner of the garage to what would be the new property line for the retreat lot.
And instead of tearing down the garage and making it happen, it would be nice to just keep it because it's a really beautiful, big garage.
It's a complement to the house that's there.
Mm-hmm. No, that's understood. That's understood. If that's the length of the presentation, then I'm going to open this up to the board. Are you okay with that?
Well, yeah, I mean, we had a few things to maybe say, but I do have to open it
No, if
first.
you want, no, this is your presentation. You take as much time as you need, as long as it's
Oh,
within
go
10
ahead.
minutes.
Um, yeah, I mean, we were just going to talk a little bit about the house. Like, when we first purchased it, it was very run down. It was needing a lot of updating, and we were originally thinking just tear it down and maybe build kind of like Carly's Ways, what's next to us, with a bunch of single family lots or even multifamily. But then we realized we could actually update the house and bring it back to life to keep that character. It's built in 1880, so it's a cool piece of property. And if we do the retreat lot in the back, it still kind of keeps the neighborhood beautiful as it is, because there's other lots similar to this in the area.
Yeah, there's we were looking at a lot of the aerial properties on the street, and by far we definitely have the biggest lot I think that has existed in a very long time. 2 houses over, there's a single family house, I think it's 136 Central, at one point was a 1.5 acre lot, and they divided it into a retreat lot with a 2-family out back and a single family house out front. We're on almost 3 acres of land, trying to kind of mimic what they did, but with a lot more property. I
Mhm.
also believe directly across the street, and presumptions from the years these houses were built, that somebody else did the exact same thing by Driscoll's Way, that they had one huge lot and then they put a little side street in to get another lot behind it. Again, I think those are only about just over an acre in combination of all the properties that used to exist. We have, I think, a retreat lot in Rockland needs 36,000 square feet to be considered a retreat lot, and we're
No,
trying to give
needs-
this retreat lot
It's twice
almost
that.
44,000. Okay, so we're still double, because our retreat
yeah.
lot is going to be 80,000 square feet. Like, we're not trying to like squish a circle in a square or a square in a circle. We're trying to keep a huge piece of property that can never be split a different way and turned into anything more than one single family home.
Yeah.
And then the front lot is still going to be almost an acre of land, when the average lots on that street are half an acre or smaller. Our
Mhm.
main lot is still going to be 0.83
3.
acres. So neither lot is going to suffer from what we are trying to do. And what we're trying to do is very typical of what is in Rockland, except
Mhm.
if you go back probably 30 years, they were building 2 houses on 10,000 square feet.
Yeah.
Houses behind houses. You go down Reed Street where my daughter lives, and they're literally houses behind houses. They're just nothing more than a single car passing driveway. And we're trying to put in something more beautiful and more fitting to what's already existing.
And it does conform in every other way except for this one little corner of the garage. So
Right.
it's not like there's any other things that need.
Well, the driveway, we would have to, I think, turn it into crushed stone. There's a poured concrete driveway that I think is the second part of it.
Yeah, it's going on. If you look at the board members, if you look at the plan, the existing driveway was it's a dash line that's on there. That's going over the property line, or the proposed property line. So what they're trying to do is, based on what I see here, they're trying to run the new line of the driveway parallel, at that same number, the 4.9 feet, just to get it off the other person's driveway, the property line.
And there's
So,
certain spots of the driveway, the way that it curves in, that it goes to like 6 feet from what would be the property line. So it's not all just the 4.9, but we know that we would be willing to reconform the existing driveway to the garage to
Mhm.
make it more aesthetically pleasing. And to, make everyone happy with what it is that we're trying to do. But I think the biggest point is we're not trying to put big houses on small lots. We're trying to give everyone so that they still look proper. Like the main house that we just redid the entire house from 1880 with all of its character and tried to keep it with like the historical farmhouse look, and the garage goes great with it. So we really just didn't want to have to knock it down or have to try and move it because it just wouldn't work right.
Mhm.
I don't know that we missed anything other than we have the frontage, we have the lot size. We're not looking to put in a development. We're not looking to put in multifamilies. We're looking to just get approval for this so that we can divide the 2 properties into still 2 very large properties so that a single family home can also be built on the street.
Gotcha. All right. Are you done now?
Yeah, unless you guys have questions for us.
No, we are definitely, I guarantee you, we
And be
definitely have
patient with us. We've
questions.
neither one of us have ever done anything like this before, so not in our wheelhouse. Sorry.
Well, welcome to the circus.
Thank you.
Mr. Baker Jr., I'm gonna get you up on deck. Any questions you have for the ladies?
You're muted.
Oh, you're muted. Yep.
I have a question first for you, Mr. Chairman.
Yes, sir.
With 4 voting members
Mm-hmm.
on this matter, what is the minimum requirement?
Unanimous.
Unanimous. Okay, thank you.
And that's why we were told to extend 2 weeks ago to today, because we had
Mhm.
the exact same issue. And I just feel like with everything that's going on, that may never not be the issue. I mean, we're coming into holiday seasons.
Yeah.
I understand you guys, it's all your time. But like, we extended to get a 5 board member on today, and we're
Mhm.
not there again.
So
Mr. Chairman, could you put the plan up or?
absolutely. Hold on
Thank
2
you.
seconds. And it's going to be kind of centralized on the house, the garage, and the area that we're looking at for the variance situation. I'm assuming everybody can see that.
Yep.
All right, thank you. I have no questions at this time for the applicants.
Thank you, Mr. Baker Jr. Steve, Mr. Galley, do you need the plan back up? I took it off.
No, thank you. No, I'm all set. I have no questions at this time.
Thank you, sir. Mr. Tanzi, can you hear me? Can you unmute yourself?
Yes, I can hear you, Mr. Chairman.
Ooh, look at that. You sound so crystal clear, sir.
So the variance, it's 4.9 feet off the off the side yard.
Mm-hmm.
Um, doesn't a detached garage have a different setback other than 15 feet off of a property line?
Can I answer that?
If this is taller than 10, if this is taller than 24 feet, it would have to be the standard 15. If it's
It is
less
not.
than, if it's less than 24 feet, based on our current bylaw, it's 10 feet.
So
It-
we're only 22 feet high.
So technically, it would have to be a 10-foot setback. So the number that the variance number that they're actually looking for is 5.1.
Okay, that's what,
So it's not that, it's not a
it's
huge.
it's not 10.1, it's 5.1.
Yeah, it's 5.1. It's not a huge variance whatsoever.
Yeah. So did they officially ask for a 10.1 or a 5.1
Let's
variance
see.
or
Let me look
relief,
at
I should say?
Let me look at the application here. That's not that one. I don't have the application in front of me. Does somebody else have the application in front of you? I'm gonna look at the,
Number 12 of the application says 10-foot required. We have 4.9 where 10 feet is required.
okay, so they're not, well, they're recognizing the 10-foot.
Okay. All right. I don't have any other questions.
All right, Mr. Baker Senior, I know I don't know if this is the first time that you've seen this. I don't know where you are in this. Do you guys, as a board member, you are more than happy to ask questions here. Yeah, you are muted, but I'm gonna take that as no questions. Okay, so now that we've got that, let's go general public. General public, is there anybody in here, and is there anybody in the general public that would like to speak in favor of this application?
Yes,
And who's speaking, please?
Andrew.
Andrew, just name and address for the record.
331 Forest Street, Rockland, Mass.
All right, and can you put your camera on so we can see who we're talking to, please?
I don't know if you want, I'm in bed.
Well, I mean, this is a public hearing.
Yeah.
You wouldn't be in bed.
I'll have someone else poke on. I'll have my mother do it.
All right, board members, if we're okay, I'm willing to let him talk without his camera on. I don't. Does anybody?
I'm fine, Mr. Chairman.
All right, and Andrew, well, if you want to, if you want to talk, please feel free.
Yeah, I just live on Forest Street, and I think, I don't see there's a reason that they shouldn't be allowed to do this.
Okay. Nice, simple, and easy. I'm glad I'm
It's
glad
been
I
a
called you
long
back.
night.
Thank you. I appreciate it, sir. Thank you very much.
No problem.
Anybody else want to speak in favor of this application?
I'm in favor.
I'm in favor. Who am I speaking with?
Kyle, come on.
And you are in favor of this application, sir?
I am, sir. Yes.
And what is your address, sir?
361 West Pleasant Street, Rockland.
Thank you, sir. Does anybody else want to speak in favor of this application?
Hi,
Hi, what's the name and address for the record?
Samantha Lordy. I'm on 66 Prospect Street.
Okay.
And again, I'm in favor. I think it's great, increased value to older homes, new development for the town.
Mhm.
Yeah, it sounds like a great thing for me.
I appreciate that, Samantha. Thank you. Is there anybody else that wants to speak in favor of this application? I saw Mr. Baker Senior's hand go back up. Did you have a question? No?
No.
Okay. All right. Not hearing anybody, not seeing anybody want to speak any more people want to speak in favor. Does anybody want to speak opposed to this application? Going. Hearing none. I'm gonna open it back up to the board members. Board members, you got any questions? Got any second thoughts? Got any things you want to talk about?
No, thank you.
Okay.
Nor do I, Mr. Chairman.
All right. Well, because I didn't do it before, you're gonna have to give me a second to pull up my cheat sheet because after 5 years, I still have not memorized this. Where is it? Over here. Okay. Here we go. All right, ladies, let's see. Now close I would entertain a motion. Close the open portion of the public hearing.
So move, Mr. Chairman.
I've got a motion in a second.
Second?
I got a second from Mr. Galley. Roll call. Myself is a yes. Mr. Baker Jr.,
Yes.
Mr. Galley,
Yes.
Mr. Tanzi.
Yes.
Here we go. All right, ladies, I'm reading a screen over here, so I'm not looking at you. The board will deliberate tonight, and you are welcome to stay. You will receive a decision in the mail with a date stamp. 21 days from the date stamp on the decision, go to the town clerk's office, request a certificate of no appeal. If no one has appealed, the town clerk will give you a certification, a copy of the original decision. Take those to the registry of deeds and have them recorded. One of the conditions is to always show the building department proof of recording. There you go. So with that, I'm good to start deliberation now. Is everybody good, or do we need time?
No, I'm fine, Mr. Chairman.
Good.
All right, talk to me, gentlemen. I'll be honest with you, I don't really see a problem with this. It's not a huge ask. As long as the driveway remains no closer
Mhm.
than the same dimension off the garage, the 4.9 feet. I have no issue here. They're showing everything right off the bat that they are going to do everything that they can to maintain compliance. They have the water easement. They're showing where the hydrant's going to end up being, the proposed hydrant's going to end up being. They're giving you the zoning, basically all the zoning offsets up in the back to show you where the house can land. And no matter where it is in that space, I did some measuring. It's within 350 feet of the hydrant. So again, the two things that they're most worried about was that front corner of the garage and the driveway itself. The only other thing that I saw is a entrance or something on the side that technically would require a variance. They're getting rid of it. They're getting rid of it in lieu of an entrance on the other side, a side entrance on the other side of the garage. So I would entertain a motion.
Mr. Chairman, it would appear that the requirements for a dimensional variance have been satisfied. With that in mind, I would that the application be approved.
I've got a motion, and do I have a second?
Second?
I got a second on Mr. Galley. So again, the motion is to approve the variance and to approve the variance for the position of the driveway. We got a motion. I got a second. Roll call. Myself is a yes. Mr. Baker Jr.,
Yes.
Mr. Galley,
Yes.
Mr. Tanzi.
Yes.
It's been a long time coming, girls. Congratulations.
Right.
Thank
Thank
you so
you
much.
guys. We appreciate you.
No, not a problem, not a problem, not a problem. Again, just once you get the decision, gotta wait 20 days. It was the 20 days, the 20-day appeal
21
period.
days.
Once that's up, go get a copy, record it with the registry, and then you go to planning board.
So can I ask a quick question?
Please go for it.
So once the 21 days is up and we go to the registry and we divide the two properties, we'll have them staked out before then and, so they can do it all right. Do we have to go to planning board or the person that's gonna build the house on there?
In order to get this to be a legally separated piece of property, you have to take this plan, all right? It's gonna have to be printed on Mylar. I think the planning board requires 5 copies, I think, 5 paper copies. So you get 5 paper copies, the 1 Mylar copy. On the Mylar copy, as well as the paper copies, you're gonna have to reference the zoning decision. There's gonna have to be your surveyor should know this. There should be a note on there, something to the effect of please see zoning case, Rockland zoning case number with the case number from the decision, as recorded with the registry of deeds, Plymouth County Registry of Deeds at book whatever, page whatever. So
Okay.
as long as that's on there, basically the planning board is able to look at it and go, oh, they needed a variance, they got the variance. Done. It should be that simple after that.
So then from what I heard, that you guys aren't gonna do a meeting in December, so do we have
Mhm.
to wait 2 months to do that?
No, not us. Not
you,
us.
the
You'd have to
planning
talk,
board.
it's
Not you guys, the planning board.
the planning board. I don't know what I don't know. I don't know what their schedule is. I
Are we
don't know
able to
when their next
request
meeting
one to
is.
be done sooner? Like, cause had emailed us today and said that the next one's not till January 27th now, which is
And like
crazy.
we're November like 18th, so that's a really long time.
Yeah, it's a really long time. Your appeal period will be up. Because you really can't do anything until the appeal period's up anyway. So
For
you would
21
need,
days.
you would need the 20, yeah, you would need the 21 after this. And then you'd still need 2 weeks you'd need a minimum of 2 weeks to get it into the planning board so all the board members can look at it. So that's 21 plus 14. Again, that's 35. That's almost another month anyway.
Right, but I think that 35 would have brought us to the end of December.
Which no boards have. I don't know of one town that has a board meeting in December like this.
Okay, all right, we'll cross that bridge when we get to it. We'll wait 21 days and hold our breath.
No, if there's I'll be talking to Allison in the morning. So if there's any questions, she'll be able to help guide you through this too. I'll also be talking to the planning board tomorrow. So I'll alert them that this is going on. I'm not
The
sure
main
if there's
reason
enough
for the
time.
question is because the existing house at 158 is done and complete, and we wanted to try and get that on the market by the end of the appeal time. But we can't sell it if we haven't separated the land. So that's where I get a little confused, and I guess I can get counseled on that tomorrow.
Yeah, I wouldn't worry about it because again, it is another 2 months, believe me, I know. So
Okay.
let me talk to a couple people tomorrow. Let me see if there's a way they get you on earlier. I tend to doubt it.
Okay.
I tend to doubt it, but because again, the planning board relies on us. So
Okay.
we'll leave it at that.
All right. Yeah. no, we'll follow
Congratulations,
that.
ladies.
Thank you
Thank
so
you.
much.
Not a problem. Have a good night.
You too.
All right, gentlemen, now we can all talk. Let me just let me make sure there's nothing else specific. No, rules of procedure. Has everybody had a chance to look at everything? Mr. Baker Senior? Did you see what I had emailed?
Yes,
I marked up a whole bunch of stuff in there.
Yeah.
I don't know, I'd have to look back at it. I don't remember if I actually have the,
I marked up mine too, but I chicken scratch and I gotta get another copy of it and make it legible.
it's here. Where do we put it? Where did I 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 put it? Trying to remember where I put this thing. I've got my computer is a mess at this point. What's the zoning changes? It was a PDF. And I can always pull it out. There it is. I think am I good? Oh, that's the original. That's the original. While I'm trying to pull mine up, has anybody got anything, on top of what I had, on top of what we've been talking about? Has anybody looked at them?
And in the spirit of confession, Mr. Chairman, I have not, but I know I will have.
Nice. Well,
Just
because
busy reading a 20-page memorandum. I didn't have time.
gotcha. No, I'm right there too. Hold on.
And I don't know what this says about me, Steve, but I love that kind of stuff.
All right.
A lot of it is we didn't have town planners and other consultants back then, and it talked about, and Steve will appreciate this, that the secretary of the planning board, of the zoning board,
Yeah.
is supposed to take the minutes and file them with the town clerk and all that stuff.
I know when I accepted it, they told me I just have to read.
I know, exactly.
Yeah, but
Well,
that's
see,
in
the
there.
thing is, when you keep going into it though, not only can we have a secretary, but we can also have, which turned into the recording secretary. There was a, what's the other word for it?
Stereo, whatever the hell I call them.
Stenographer or something?
Stenographer.
Stenographer.
Yeah.
All right, so
Yeah.
that's the recording secretary, but I mean, we used to be able to have a lot of different people. So
But
I'm still trying to find the one that I threw in,
some of the other things were, just to bring it up to today's, the 21st century, is they talk about chairman, vice chairman.
Mhm.
I think we should change it to chairperson, vice chairperson.
Yeah, I mean, that only makes sense.
You know,
That only makes sense.
just to go with, because all the other boards in town are doing the same thing. The selectmen did it, you know. And I had a thing in there, and it was brought up before, that terms for the chair, vice chair, secretary, as far as you had mentioned, you know, that there should be, or we should think about having a time period for the chair to be the chair.
Oh, it should revolve. It absolutely should revolve. I
Right.
mean, I 100% agree with that.
I was thinking a 2 or 3 year stand, and then they would have to, because it states in our rules and regulations now, the first meeting in May
Mhm.
is supposed to be when we reappoint or appoint new chair, vice chair, and secretary. I think we should leave that, because it's April for town election and town meeting. It was, I don't know either, because of what Allison mentioned to the petitioner earlier about the 10-minute rule. I don't think we should have anything like that in there.
I agree.
It should be up to the discretion of the chairman, that if the speaker is babbling on and repeating himself and stuff, then you could do like you've done in the past. Is there any, when we did shingle mills, in fact, is there anything new?
Yeah.
that you-
Right.
Okay.
You don't, yeah.
Yeah, get off your soapbox, and sorry, Bob, but
Okay. That works. So
Yeah.
leave it in it. So leave it in the hands of the chair. Let the chair instead of having just a time period.
right,
I don't mind that.
because I think that could potentially end up in court. Someone could challenge that
I don't.
and say you didn't. Well, if we denied something, they could say, well,
Mhm.
you didn't give me enough time to present my case.
It sounds like it could be an arguable.
Right.
And I imagine you can ask Attorney Galvin, but I think, Rob, your premise has often been, don't just repeat what you've already submitted in writing verbatim. So I think I would imagine you'd be allowed to enforce that general rule of, summarize what you put in there. Don't read it all out to me, you know?
Which is what the last guy was going to try and do, kind of.
Yeah.
So,
right.
Whatever. I'm sorry. I didn't mean to bring up past. I'm sorry. I apologize. Okay. One of the things that I was looking at, the last 4 of the rules of procedure, it's the last 1, 2, 3, the last 4 pages talk about chapter 774 in the hearing procedures. That's all now chapter 40B.
Right.
So that whole thing needs to kind of be, I don't know if it's, again, I haven't gone apples to apples to see if there's an absolute 100%, it's the same or not. It probably isn't, but it definitely needs to be updated to the 40B regs. And again, I'm looking at it, applications, let's see, the hearing procedures and stuff like that. I'm pretty sure that's dictated already in our zoning bylaw. So if it's literally take that copy of the zoning bylaw that we have, tweak it if we have to, but it sounds like that's what has to go there. And then just so everybody said, can you say they saw it? This is what I sent out a while ago. This is just, I didn't try to come up with a ton of answers or anything, but like this number one, a quorum of members under A of this section shall not be less than 5 members.
Yeah,
That goes against what we've been saying.
Well, I mean, typically for even governmental bodies, a quorum is 50% plus one.
50% plus one. So
So
that would be 3 members.
right
No,
now,
no, 5. Yeah, 5. It would be 2.5 plus 1, technically 3.5.
it would be 3 members. Now that doesn't mean that we could transact all the kind of business that requires other population or other attendance. There are certain things that require more than 3 votes, right?
Well, there's a bunch that is and 3 votes is only under rule of necessity. Is rule
Yeah,
no,
but-
I don't know.
My point is we can have meetings, but even if we have meetings with only 3 people, there's a lot we can't do.
Oh yeah, there's a lot that we shouldn't do.
What
So-
about,
so is that-
what about the 2/3 vote?
See, this is where it gets weird. This
2/3
is where
vote.
it
What
gets weird. I just, that's
requires
why
a
I'm like,
2/3 vote?
Well, what,
that's why
what-
I'm questioning. That's why I'm questioning the number. I mean, is a quorum for us 5 people? We've held that not to be the case.
Right.
right.
So
I mean,
that's just it.
I've never heard of any body or any corporate entity that requires 100% attendance as a quorum.
That's my point. So that it's just, again, it was a
Yeah.
question. I don't know what was going on there.
I got a
Well,
question
Mr.
about
Chairman,
that.
Yep.
Okay.
it says for this 5 members, it says a quorum of members under A of this section shall be not less than 5. And A is for making rules established by the board, may be amended or repealed or otherwise acted upon by a majority vote of a quorum of members who may be full or associate members. So the quorum is 5, but
Mhm.
for rules established by the board to amend, repeal, or otherwise act upon, it has to be by a majority vote of a quorum, which would be
All right,
4
so there are,
members.
okay, so a quorum of members under A. So
Yeah.
basically, anytime there's any rules established by this board can be amended, repealed, or otherwise acted upon by a majority vote of a quorum. So if we're making it, if we have to have a quorum of all of us, we all have to be there in order to talk about this.
But that's only for the purpose of the stuff we're talking about now.
That didn't make any sense. I apologize.
All right, I got a question.
Yes.
Okay, so the quorum of 5 members, was there a 9-member board at that time?
There
In
was, no,
1980
it's always been a 5-member board, but we have seats for 3
Alternates.
alternates.
Oh,
So
okay,
in the absence of one of you guys, the alternate could step in.
oh, okay, so this officially is a 5-member board?
Yeah. Yep.
Okay, and we have 2 alternates.
3. Technically, we're supposed
Well,
to have
3, right. We have 3 alternates. Okay.
So when Greg doesn't show up, or when Mr. Baker Senior doesn't show up, or when I blitz and I don't
Yeah.
show up, there's other members that could step in, and we could still have a 5-member board.
So with the 5-member board, is a quorum universally defined, more than half, or
That's the typical, Steve.
okay. So
And
basically,
I
right.
wouldn't say it's universal.
Okay. So, all right. So typical, a quorum for a 5-member board would be 3 members.
Yeah.
Okay.
But again, because of the voting requirements for certain things, we could meet, but we couldn't do anything. But as Greg pointed out, there is an exception to even discuss changes of the rules. There have to be 5 members present.
Now, what if we don't have a 5th member? What if we only have 4 members?
Then you run into the shingle mill that we had, where we only had 3 voting members.
Yep. So I mean, if we
40B, and we were able to make that work.
So if we had 4 members, could we consider 3 a quorum? And then can 4 act otherwise as a full board?
It depends on what you're acting on. If it's not to amend the rules, possibly. But if it is to amend the rules, I don't know. That's a question for Bob, I think.
Steve, do me a favor.
Yep.
That question needs to, I need the answer to that question. I think everybody else needs the answer to that question. Can you just write that question down and email it to me, and then I'll get it to Bob, and then because I'm in the process with him trying to come up with the first section of training course for everybody. That's gonna be part of it.
Yeah. Thank you. Will do.
So the next thing that I wrote down here was meeting and hearing definitions. We've got the definition of a meeting. I'm being told that the definition of a hearing is it's a meeting, but the abutters get notified. The abutters get notified. That's what I'm being told is the definition of a hearing.
So would it be a duly posted meeting for a specific hearing?
Again, I don't know. I don't want to know. I just pointed it out.
Yeah, let me give you an example. If we have if we have stuff to vote on, that is a hearing held within a meeting.
Okay.
If we're just talking about, I don't know, let's say we have a meeting to establish the meeting calendar. It's the only item on the agenda.
Yep.
That's just a meeting. That's not a hearing.
Okay.
I mean, that's not a particularly, thorough definition, but just to give you an idea. And
believe me, I dig it. I know that in my head, I know the definition, but I can't put it into words right now. I think that it would be nice if we could have one more definition under the definitions page. It would be nice.
And I hate to do this, but this won't disturb your quorum. I have to go.
No, do what you gotta do. You've got you got this copy, right?
I did.
Just run through, look at the colored sections. I didn't try to answer anything. I just pointed out things that I think kind of need to be changed.
Okay.
That's all.
All right. Thank you all. Have a good
All
night.
right, sir. Guys, if you want to hold the same thing together, again, I didn't try to answer anything. I kind of just like threw out there what, just like kind of questions and pointed out what I kind of think needs to change. There's a couple places where I did put, if you look on, I'm still sharing my screen. Chairman powers and duties. If the chairman is absent or unable to serve in a meeting, the secretary shall serve.
Right.
It should be the vice chair.
Well, of course it should be the vice chair. So that's why, that's why I put that's why I put that stuff. This section.
It should also say if the chair or vice chair cannot, then the secretary would take.
Well, we don't have a secretary.
Steve.
Well, I'm a secretary, but I'm not.
No, you're not the secretary. You're the clerk.
Oh, the clerk. You're right. I'm the clerk.
All right, you're the clerk.
You're right. I'm the clerk.
If you wanna be called secretary, hey, we could do that. I know there are guys secretaries out there. I just think
it's not an issue for me, but there's a lot of letters and syllables involved.
I would rather clerk. Nice, simple, easy.
Clerk is more.
Okay, so maybe we need to change that. Maybe we need to change that position. Get rid of the secretary because unfortunately, our secretary has been removed from us, and it's been turned into an actual full municipal position. We used to have a secretary, and that secretary was funded by us, and we were paying her $250 a meeting, and that's all she was getting. But unfortunately, I'm not going to go into past history and why it changed, but 250 a meeting was never enough to cover what the secretary for the zoning board actually did. There's no way in hell $250 covered it. And that's why we had to have, that's why Deb's position got created. We tried to have, it was Candy's daughter be the secretary. She couldn't do it. There was way too much for her to do. For 220, it's a good side hustle, but it's not it's the amount of work is an actual position. It's a job. So we don't have a secretary. So that's why I think clerk might be better. Because the other thing is a recording secretary. We've had that. And the recording secretary, the only thing that, and that's what Deb was when she was at the meetings. She was the recording secretary, not our secretary. She held the position of getting the 250 a meeting. So we can have a recording secretary. I almost prefer the word stenographer. Go back in time a little bit, but I mean, either way, technically, we don't have a secretarial position in this other than the recording secretary or stenographer, if you want to go back that way. So that to me says that the definitions and the title definitions need to be changed. And actually, you can see I put it here, vice chair and clerk.
Rob,
I'm sorry, what was that?
I heard that they were looking or advertising for,
Oh, they got somebody.
oh, they do?
Oh, they got somebody. They got somebody, and we're gonna, and between me, Mike Corbett, Allison, and Christine, we're gonna kind of sit down with Courtney and try and come up with they've already got a, what's it called? Onboarding. They've already got an onboarding procedure for her that they've kind of created and tailored for this position, which never existed before. That was with the help of the current HR director, Lori, I think her name is. So that's all happening. That's definitely all happening. So there's going to be a sit down to discuss the onboarding, and then she's going to come in. She's going to talk to, we're going to talk to her, this, that, the other thing. What else we got? Secretary, that's why I put this whole thing. Not sure about the secretary thing. I thought this was kind of a thing, and I don't know. I don't know how to do this without putting this in. And I don't know if it would be considered stacking the board or not. But I know that in the past, when I first got onto the zoning board, when Greg, you'll know him, it was McDermott, Peter McDermott.
Yeah.
Yeah.
He was on the board when I just got on. Same thing with Tony
Paterno.
Tony Materna. When he was on the board, when it got to something that was like survey based or survey, you need an understanding. Both of them, one or the other of them, would recuse themselves from the meeting, from the decision, in favor of Bob putting me on the board. I don't know why. I mean, I think it was just get better, to learn, I think. So, I mean, I don't know. I think being able to step it up when we have associate members, we're going to have 3 associate members that more than likely are going to have absolutely no clue about what we do. It would be nice to be able to appoint one of those members for that meeting and say, hey, step up. You're going to be a board member. It's time to learn. I don't know. So that's just a thought, going along the lines of rotating board positions. I kind of thought that was like a cool idea. What else? Number of copies, that's got to be changed. I mean,
Yeah,
it's such a waste of paper nowadays. And again, I don't care about paper. Typically I get everything via email, typically. But the other thing was I never had to worry about getting things by email because everything was published online. Deb always made sure to have everything published online. Allison's not doing that. So up until tonight, I've never had an issue not getting something because it always had to be published online. I'm not a fan of email. It's just or relying on email. So it would be nice to deal with of number of copies and a requirement that even if we're not on Zoom anymore, we have the website. It would be nice to be able to, even in the advertisement, even in the agenda, in the advertisement, provide a link to the documents for that meeting. Here's a link to the documents. You can go right on your computer, hit that link, and it'll bring you right to the documents for that meeting. And if we have the technology, it'd be nice to be able to do that.
The other
How do
thing
I
is
say
the,
this? I
the,
need
the
to
fee,
review and get-
the $35 fee.
That's been changed. I think that's gone up. If you look at our current application, that number's gone up. So this definitely needs to be changed.
Yeah, we'll have to look at what the fees are now and add them in there.
Yep. The plan requirements and stuff like that, I want to go over that because that's like a minimum. There's a lot of minimums there. And quite honestly, the standard of survey plans nowadays has gone severely up. So I want to make sure that the current standard is met. Is just there's still surveyors out there, there's still surveyors and engineers out there that think you can do simplistic two-dimensional plans nowadays and get away with it. Site plans. We need full topographic site plans nowadays because typically when somebody's trying to come to us for a variance, Bob, you've seen this, you know this. If they're not representing the actual topographical nature of the lot, and then talking about, oh, well, it slopes off towards the end, prove it. You need to be able to prove this stuff. So, typically, a topographical site plan is the minimum that surveyors are generating for clients now. So, if that's the case, then I'd like to get
It should be up front.
our standards up.
It should be right there up front.
I agree with that. All right, the section 2 notification, or this is where a pre-file review should come into play. I spelled that wrong. Before the TC stamps it in. We've been doing between Mike Corbett, John Lucas, myself, Gregor, you actually have a job, so it's not like I can get you to these pre-filing meetings. People that can make it. We have these pre-filing meetings and we go over applications before anything gets stamped in, before the town clerk sees it. That way it's making sure that the application is 100% sound. It has everything in it that we could possibly need to make a determination. We also go over the site plan. If the guy's trying to get away with something, or if he's trying to do something that definitely is not going to work or is going to break bylaws and stuff like that, at least we know that going into it. We point out all the issues, say, look, you're going to have problems here, 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 zoning setback here, the number of parking spaces here. We go over that with him So when it does come time to stamp it into the town clerk, everything, all the stupid answers are taken place. So that's why I put that there. Again, recording secretary, I mean, I'm looking at, just definitions and stuff like that. What did I do here? Oh, this is what I was talking about. The chairman shall read, then the petitioner, then those in favor will be heard. We've never done it that way. Been doing this for 15 years. We've never done it this way. I numbered it the way that I think it should go. The chairman shall read, petitioners and representatives will make their presentation. Members of the board desiring to question the petition will be heard. General discussion if we have, if we can. And then, those in favor, those opposed. And then the open portions is closed. That's how we've done it. That's how we've been doing it. And I think we should go back to that. I think I think it should be in there like that, but again, everybody else can talk about it. Any hearing under oath, he shall determine the form of said oath to be administered. I put question marks in there because I don't know what they're talking about. I don't know what at my discretion conduct a hearing under oath. I would like Bob Galvin to kind of explain that to me so I know what I'm dealing with there.
You mean we all gotta raise our hands?
See, that's my point. I mean, I don't know. I mean, it just doesn't make any sense to me.
I know. I kind of questioned that one too.
The question, the chairman shall cause to be recorded by the stenographer the names of all council appearing. That's already, I mean, I think that can be reworded, but I mean, that's what the stenographer or the recording secretary was already doing to begin with. Again, I didn't have any issues here. Again, recording secretary, do we change that? Yeah. I ain't writing the decisions. I don't think any chairman should be responsible for writing the decisions. Because quite honestly, if you want to keep this in here, I can tell anybody to write the descriptions. Not the descriptions, the decisions. This chairman shall write and file all decisions of the board. Nope.
Or at his discretion, may assign the writing and filing of any decisions.
I don't think that the writing or filing of any decision should fall on any board member.
Right.
That's why we have secretaries and recording secretaries.
So we should just put down the secretary shall
Exactly.
write and file all decisions of the board.
Yep.
And
Let's not try and come up with answers. I
Right.
don't want to sit here and come up with
Yeah,
answers.
yeah.
I mean, just general discussion and stuff. But does everybody agree that,
Yes,
whoever the
that
chairman is,
should
they
be-
shouldn't?
that should be changed too.
That's why we have secretarial positions.
Right.
So we don't have to get our hands dirty. So, contents and distribution of decisions. I didn't see any issues there. Obviously new date of acceptance. And then I put this in here. This kind of was a thing. All decisions shall be signed and dated by either the chair, the vice chair, or such other board member that was designated to run the meeting hearing in the absence of the chair or vice chair. So again, if I'm gone, Bob Baker takes it over. If I'm gone and Bob's gone, now you're down to 3 people.
Right.
Somebody's got to open the hearing. Somebody's kind of got to run the thing. And typically with a 3-member board, you're not going to be making too many decisions, guaranteed, especially in the absence of the chair and the vice chair. So typically whoever's running the meeting would make a
Just open it and close it.
Well,
for
basically,
continuation.
they would have to open it if it's a hearing,
Right,
continue it. And if it's something that didn't require public not public notification, but a butter notification. If it didn't require a butter notification, if it was something that didn't require, that wasn't changing any of our rules or anything like that, you could probably talk about it and make a decision, but it's still, microphone.
no, that sounds like a good idea.
Uh-oh, there it is.
There we go. I put on my earphones. Maybe I muted myself when I did that. I was going to say, if we had two alternate members at that point, if the chair and the vice chair aren't there on vanilla projects, could we
Yep.
continue with a technical full board?
Absolutely.
Okay.
That's why they're
Yeah.
there. You know,
Okay, just
that's why we
asking
kinda-
just in case, you know.
Oh
But
yeah,
right
no,
now
no,
it-
that's why,
Yeah.
that's the whole point of that's the whole point of the associate member. Not
Yep.
just to learn, but to cover our butts when
Yep.
we're, for some reason, can't be there. So
Yeah.
I think that something like, that's why I put in there, to run the meeting hearing in the absence of chair or vice chair. So
Yeah.
I think that, again, when it comes to signing that, and then everything else is 40B regs. So that's what I've got. That's all the different
Right.
things that I was concerned with or something like that. Again, not looking for answers on any of it. This is gonna take time. I'm assuming that everybody else is gonna have something. Bob, you're gonna take yours and you're gonna do this, kind of do the same thing that I did.
Yeah.
We go over that. If Steve, if you're gonna do it, Greg, if you're gonna do it,
Mhm.
if Mr. Baker Jr. is gonna do it, we should go over each and everybody's one. Or we just combine what I've got and what Bob's got, make some decisions piece by piece, and just call it done.
Hmm.
I agree with Mr. Baker. It has to be updated. This is ridiculous.
Mhm.
So, all right, what do we got? Anything else?
Motion adjourned.
I got a motion. Do I get a second?
I'll second it.
I got a second. We got a roll call. I got myself as yes. Steve Galley,
Yes.
Gregory Tanzi,
Yes.
Robert Baker Sr.
Yes.
Smoke 'em if you got 'em, guys. We're out of here.